Okay, thank you. It's 9 o'clock in the morning. This is the Children at Risk Faith Healing Working Group, and I'd like to welcome all of you today in attendance. And for those of you at home listening, we welcome you too. And we will do our best to try to keep you in mind when we speak into the microphone or ask questions so that you can participate to the fullest extent possible. My name is Senator Dan Johnson. I will be co-chairing this working group along with Representative Joe Palmer. We're going to open this meeting up with just some brief introductory comments, and then we will move into the meat of the order. So, why we're here today? We were asked by the governor's office to convene a review of the Child Fatality Review Report and to look at the current statutes in Title 16 and Title 18 that deal with the faith healing and prayer exemptions, and also possibly come up with some suggested changes to those or not. But we've been asked to do a thorough review of that, and so I'm committed to that, and this committee, this working group, will also be committed to that, and we look very much forward to your participation in this and your involvement in this. I'd like to just throw out a framework for our conversation over the next few meetings and try to focus our discussion, focus our questions, focus your concerns, your comments to this working group on where I think some of this should go. To me, the issue is really about balancing interests, those of the state and those of the parents. And I think that's very key. And if we can stay focused on that, I think it gives us an understanding or a framework from which we can work under and don't go down too many side trails and get distracted by that. There's a lot of strong feelings about this issue on both sides, and I respect that, but I want to stay focused on what our task is here. And I think as we go through this, we're probably going to come up against some questions dealing with religious freedoms, dealing with due process, possibly looking at establishment clauses. I don't know what kind of questions we will get through this, but that's part of our job, is to evaluate these statutes in that context. I'd also like to ask any of our presenters today, especially those coming from our interested citizens, if they could also try to focus their comments around that framework and to think about these interests. So in other words, if you have comments to submit and you think that the state's interest is adequately represented or it's not, then please comment on that. If you're a private citizen and you think that your interests are adequately represented or not, please comment on that. It'll help us, I think, focus on that rather than getting hung up in numbers and strong feelings about one way or the other. And I would also like to ask that of our committee members too, that when we ask questions, if we can kind of keep that in mind so that we can help sharpen some of our focus on this framework. Representative Palmer, would you like to share opening comments with us today, please?
Thank you, Senator, and I'd like to thank everybody also for being here today. This is an extremely emotional issue, I think, for everyone in this room, and I hope that as we go through and speak of these matters that we'll be able to do our best to try and keep our emotions in check and talk about the facts that we need to talk about. We need to discuss the legalities and the statutes that we have so we have a good understanding of them, and I would really trying everybody to, I know it's hard. It's hard for me in this kind of a situation, but I hope everybody can try really hard to stick right to the facts that we're talking about. And when somebody's ahead of you and has said something, try not just to repeat the same thing they have. I know that there's going to be overlap, and we'll allow that, but just do your best to try and bring out any of the facts that you need to at that time. And I'd just like to thank everybody for being here.
Thank you, Representative Palmer. And with that, I would ask if Nicole McKay and Mary Jo Beig, is that how I pronounce last name? Please take the podium. And Ms. McKay, if you would introduce yourself to the working group, state your name, who you represent, and your purpose for being here today. And for all of our presenters today, when you come up to the podium, we would ask that you do that for the record, to speak clearly into the microphone, loudly. And it's not a race, so it's okay if you speak slowly too, and then we can better understand what you're saying. So, Ms. McKay.
Thank you. Senator Johnson and Representative Palmer, members of the committee, I thank you for your opportunity for Mary Jo Beig and myself to present at your Children at Risk Faith Healing Working Group meeting today. My name is Nicole McKay, and I am the Attorney General's Chief of the Health and Human Services Division. With me today is Mary Jo Beig, who is also a Deputy Attorney General with the Health and Human Services Division. Mary Jo has been with the Attorney General's office since 1991. She represents and provides legal support to the Department of Health and Welfare in Child Protective Act matters, including child protection cases, termination of parental rights, and appeals. She is a certified child welfare specialist and is a member of the Idaho Supreme Court Child Protection Committee. She brings a wealth of experience in child protection issues. With that introduction, I will turn the podium over to Mary Jo so she can present to you on the constitutional questions and the interaction between the Department of Health and Welfare and these child protection issues on the legal side.
Senator Johnson, Representative Palmer. I was asked to speak about the law governing, the constitutional law providing information as to the religious exclusion pieces, particularly with respect to the constitutional basis for some of these, for this provision. Under the United States Constitution and the Idaho Constitution, the individuals are given basically the right or the free exercise of their religion, and there is a liberty interest to establish their rights to parent their children. Since 1925, the United States Supreme Court has weighed the private interest in freedom of religion against society's interest in protecting the welfare of children. The United States Court has consistently found that neither the rights of religion nor the rights of parenthood are limitless. While parents have a fundamental liberty interest in directing the upbringing of their children, protected by the Due Process Clause as their right to their exercise of religion, the state's interest in the protection of the welfare of children is allowed to infringe on this interest. Each state has a wide range of power for limiting parental freedom, seen in matters of religious conviction or conscience. Activities of individuals, even when religiously based, are often subject to regulation by states in exercises of their power to promote health, safety, and the general welfare of children. This is referred to as the doctrine of parens patriae. States have a substantial interest and duty, in fact, in preventing the abuse, neglect, mistreatment of children, as well as promoting their general welfare and their health in the community. The right to practice religion freely does not include the right or liberty to expose the community to a child who is in ill health, to expose the community to deaths of children, and there are other provisions that they have set out in federal law in the Supreme Court to limit those rights of those parents. The Child Abuse Prevention and Treatment Act, also known as CAPTA, it was a federal provision that in 1974 included language basically stating that you could have a religious exemption. That language was removed by the federal government in 1983. At this time, there is no federal requirement that a religious exclusion be in place, and federal funding is not tied to the inclusion or leaving this provision in the statute. Under the Idaho Code, under 1616.01, the legislated policy of the Child Protective Act is the protection of any child whose life, health, or welfare is endangered. At all times, the health and safety of the child shall be the primary concern, so the rights of the child come first. The policy provision provides that necessary action be taken to prevent abuse and neglect and abandonment, if possible. The definition of neglect includes basically a religious exclusion provision or exemption provision. And I will read through what the neglect statute says, including the language, because we may need to talk about how that is phrased in the statute. A child neglected means a child who is without proper parental care, control, or subsistence, or medical or other care or control necessary for his well-being, and because the conduct or omission of the parents, guardian, or other custodian, or their neglect or refusal to provide those. However, no child whose parent or guardian chooses for such child treatment by prayers through spiritual means alone, in lieu of medical treatment, shall be deemed for that reason alone to be neglected or lack parental care necessary for his health and well-being. But this section shall not prevent the court from acting pursuant to 1616.27. 1616.27 provides for a court to issue an order for emergency medical treatment when a physician gives his opinion that the life of the child may be greatly endangered without certain treatment, and the parent, guardian, or other custodian refuses or fails to consent. The court is required to take into consideration, and the statute basically says just that they need to take into consideration any treatment being given the child by prayer through spiritual means alone, if the child or his parent, guardian, or legal custodian are adherents to a bona fide religious denomination that relies exclusively on this form of treatment in lieu of medical treatment. What is notable about this particular statute is that it says the physician informs the court. The child does not have to come within the court's jurisdiction under a Child Protective Act case. The department does not have to be currently investigating the family, and they do not need to be called in to investigate the family. It basically provides that the physician will inform the court. I will defer to Ms. Fisher because I believe that they have a process set up with the hospitals to ensure that this happens. The religious exemption is the only place in the Child Protective Act that places the parent's right before the well-being of the child. So a faith-healing parent is treated to a different standard than any other parent. There is no Idaho case law that construes this provision. So we look to other states to see what and how they have interpreted it. When we do this interpretation or a statutory construction and we're looking outside of the state of Idaho, we look at the statutes and whether or not they are crafted with the same language that Idaho has utilized. A statute that was closest to Idaho's statute was Colorado. The case law in Colorado basically provided in interpreting the statute or the language of alone and in lieu of medical treatment to mean that you had to find a separate ground of neglect. You could not rely on the ground of the faith healing to bring a child into care or to find that a parent has been neglectful. You had to rely on a whole separate ground. So an additional reason or a separate reason would have to be evaluated or found before the Department of Health and Welfare or the prosecutor's office could file a Child Protective Act matter. A parent who raised the defense that the reason that a conventional medical treatment was not sought was because the parent chose treatment for the child by prayers through spiritual means are not held to be neglectful. But a parent who does not assert a religious exemption for the same factual scenario would be found to be neglectful. A parent should be, generally what happens is parents should be held to the same standard. If the freedom to believe is absolute, the ability to act on those beliefs or to practice those beliefs can be subject to regulation. And that is why the Child Protective Act exists, to assure that children are not abused, abandoned, or neglected, that they receive the treatment that they need, the food, the subsistence, and the medical care they need for their well-being. If there are any questions?
Representative Trujillo.
Thank you, Mr. Chairman. I do have a question as far as, and I'd like to bring this forward. We say that it's a full exemption, and yet we use the words alone and in lieu of. Can you explain to me why you feel this is a complete exemption for these particular parents?
It's the way the statute is crafted. Basically, how it is set up, it basically says that a parent who chooses treatment by prayer through spiritual means alone, and that's in lieu of medical treatment, shall be deemed for that reason alone to be neglected or lack parental care necessary for his health or well-being. So they will not be neglectful. The way the statute is crafted, it basically states that if you are saying that your child broke their femur and you are praying to resolve this medical issue, the Department of Health and Welfare cannot say that you are a neglectful parent because you are not seeking medical treatment, because you are asserting your right to pray for that child and to treat that child in that fashion. The Department of Health and Welfare would look for a separate reason to bring that child in care, or they might pursue and look at 1616-27 to see if a court would order treatment of that child for that injury. But it's not, if they were going to find a parent neglectful, they would have to establish that there was a secondary issue of neglect.
Follow up?
Representative Trujillo, please speak into the microphone too so everyone can hear. And Ms. Spike, if you would speak through the chair too, please. Thank you.
Oh, I apologize.
Thank you, Mr. Chairman. Just to clarify, so the full exemption would be in Chapter 18, is that correct? Or is it through Chapter 16 of the statutes?
Ms. Spike.
Senator Johnson, Representative Palmer, I am not speaking to the criminal statutes. I will defer to Ms. Fisher, who is coming after me.
Thank you.
Senator Schmidt.
Thank you, Mr. Chairman. Ma'am, I do actually want to focus on 1627. And so the way I'm reading that right now, even with what we call the other sections of code where there's religious shield for neglect, criminal, this is a way in which right now in Idaho statute, if a child was identified to be in danger, a court could intervene. Am I interpreting this statute correctly?
Ms. Spike.
The Senator Johnson, Representative Palmer, the way the statute reads, and the court could intervene if they are notified of the child and the child's circumstance. It would require that some third party, such as a physician, would have to call and request saying this child has this injury, we need to treat this child for this reason, and get the court to order that. So it is a method, it is a way to have that done if the child is greatly endangered.
Follow-up.
Senator Schmidt.
Thank you, Mr. Chairman. Thank you for the follow-up. you've described that there is a process now. Are you aware that this is being done right now in Idaho? Are there cases in which the court has intervened for the well-being of a child?
Ms. Spike?
Senator Johnson, Representative Palmer, I am not aware how frequently this provision is utilized. The Department of Health and Welfare is not always notified when this happens, and they do not always do an investigation to determine if there are any other basis for concern with that family. So they do not always track those figures. They look at the information when it is known to them, but they have to, unless it's reported in some fashion through their community partners, there is a possibility the department wouldn't be aware of it. So it is a provision that is utilized, and I believe that it is being utilized in the state of Idaho, but how frequently, I do not know.
Just as a clarification, Mr.
Senator Schmidt.
Chairman, thank you. I would think it sounds to me like the court is involved, so wouldn't the court be counting this?
Senator Johnson, Representative Palmer, yes, the court is required to craft an order, a written order, if this has in fact happened. I do not know what the Supreme Court statistics would show with respect to this, and I do not know how it is tracked in the current system.
Senator Sidaway, Ms. Spike, if you just address it as Mr. Chairman, that's fine. It'll save you a few words. Maybe we have a long time. Senator Sidaway.
Thank you, Mr. Chairman. I guess my question, or I probably don't understand when you were talking about you have to have a separate reason to move forward. Could you back up a little bit and give me some examples if there's a child that's sick and that's brought to the attention of the state, and are you saying that the state has to have a reason to move forward to intervene on behalf of the child? Well, I just don't understand, I guess. If the state gets involved and there are prayers being offered, the state makes the determination that that's not sufficient treatment for that illness from that child, then does the state have to find a different reason to move forward to advance, I guess, some medical participation in that? Could you explain that a little bit and give me some examples?
Mr. Chairman, let's go back to my example. And yes, the state does look for an additional piece. So we have a family where each family has a child who has a broken femur. One parent or one family is treating that child through prayers alone, and the other family is basically putting a cold compress on that and not seeking medical care for that broken femur. That, let's just assume for the sake of argument, that child's leg needs to be set or treated, or it could be a life-endangering circumstance. The Department of Health and Welfare, when they went out and investigated, would have to evaluate whether or not there's another reason. So if the child was placed in a dangerous circumstance where he fell and how he broke his leg, that might be the reason to bring the child into care to find the parent neglectful. Just because the parent is treating the child through prayer alone, that does not rise to a finding of neglect. The other parent who does not raise that exemption and is just treating their child with an ice pack, the department would go into that circumstance and most likely, if they're not able to voluntarily work with that family, which they do try and do, that child could and that parent could be found to be neglectful.
Okay, thank you.
Representative Harris.
Thank you. Chairman, so in 161627 then, even with this exemption being claimed or asked for, the state could still override, upon doctor recommendations, the faith healing parents' wishes to not receive treatment. Is that correct?
Ms. Pike.
Mr. Chairman, the court could override with their decision to have the child treated. So if a physician is aware of the child, they can make the call to a court, and the court can order that treatment if they are aware of the child. I don't know if I've answered your question.
Representative Harris.
If they're aware of the child, they would be aware of the child, obviously, for it to come forward. So what are they allowed to do separately than what might be allowed in 161601?
Ms. Pike.
Mr. Chairman, the Department of Health and Welfare would investigate the case if they're aware of the case, and they would evaluate whether or not that child was endangered in some fashion, or whether or not that parent had been neglectful. Under 161627, excuse me, the department doesn't necessarily know about it right at that moment. It doesn't necessarily correlate that there would be a referral to the department. There may be a referral. But the issue then becomes, does the department have a separate, do they do a separate investigation? They take into account and they understand the parent has provided information that they're treating through prayer alone. Excuse me. The court is allowed to order that particular treatment for that family without a finding of neglect.
Representative Harris.
A separate question then. What if the parent is not attempting to use this exemption, but feels that the reason they're not seeking medical treatment are for other reasons? Fear of infection from hospitals, or they feel like they're doing an adequate job. So it's not neglect, but in their best interest of the child are pursuing other means for the child that the state doesn't approve of, perhaps, but from the parent's point of view isn't neglect, but acting in the child's best interest. How would that play out?
Ms. Pike.
Excuse me. Mr. Chairman, Representative Harris, the Department of Health and Welfare would investigate that and could conceivably find neglect.
Senator Schmidt.
I guess, Mr. Chairman, I'm looking for clarification in terms of, because it seems like in 1627, it is the court's role to intervene, and then I'm now reading 1601, and I keep hearing you refer to the department as having authority, and I can't find, 1601 clearly does state the state's obligation at all times. The health and safety of the child shall be the primary concern. And then I hear you make reference to the department, and I'm not sure how that link is made.
Ms. Pike.
Mr. Chairman, Senator Schmidt, the Department of Health and Welfare is basically the investigative agency under the Child Protective Act. It's their responsibility under 1616-29 to investigate all referrals that come in that deal with children who are abused, abandoned, or neglected. So when I'm referring to the department, I'm referring to the Idaho Department of Health and Welfare. The court is the primary person, but the department does not, and the court does not have to find that the child comes within its jurisdiction to order treatment under 161627. They just have to, based on a physician's recommendation, make the decision that that child should receive treatment. That child would not necessarily come under the court's jurisdiction of the Child Protective Act. That doesn't mean the court wouldn't make a referral to the department if the department was not already involved.
Thank you, Ms. Beig. And if I'm correct, I think that's also a good reason for the court not to intervene. They may have to have a good reason for, if you will, usurping that parental right, custody of the child. And so that's a decision I would imagine is a very serious one that they would have to take, and on the advice of the medical doctor. But they have to consider the treatment that's being offered through prayer or other spiritual means too. So my understanding is in that the court, as you say, may or may not intervene in that, given that balance test that they have to look at.
Mr. Chairman, I think what it comes down to is how it is perceived and the danger to the child. If there's going to be a chronic injury, if there's going to be a disability, if there is the potential of significant life-changing event, then the court will evaluate, based on the information that the physician has provided, whether or not they should intervene. Now, just to give an example, if you have a parent who is refusing to immunize their child or attend well baby checks, and physician calls and says, I want a court order to make that mom come in, this is a healthy baby, but I want to do my well child check and I want to immunize the child, it's unlikely the court would intervene at that point, simply because that's not a significant medical issue. And so it would be unlikely that the court would take any action whatsoever and could say no. Ultimately, the court does have the ability to make that choice. But in 161627, that provision basically says that the court shall take into consideration any treatment. They can take it into consideration. They can choose not to believe or choose not, let me rephrase that. They can choose not to accept that as the necessary treatment for that child at that time and then order treatment.
Representative Gannon.
Thank you, Mr. Chairman and Ms. Beisch. So I just want to make sure that I understand what you're saying here today, and so maybe if I can paraphrase it. And you're saying that if a child is taken to a doctor or a medical facility, or maybe the school nurse observed, I guess the school nurse could also report if a child was at school and had some debilitating illness or something. If that occurs, then 1627 comes into place. But if the child is not taken to someone who would report to either health and welfare or the court system, then there would not be, 1627 would not come into play. Am I understanding that correctly?
Ms.
Mr.
Beig.
Chairman, Representative Gannon, yes. Idaho is a mandatory reporter state. So basically, there's a list of individuals, doctors, social workers, nurses, a list of people, and then it says other persons. Basically, anyone who sees that a child might be endangered is required to report. So Idaho is a mandatory reporter state. Just because it's a mandatory reporter state doesn't mean that a person is going to report. The Department of Health and Welfare, if there is a referral, will investigate. If a child is in school, School nurse will notify either the resource officer and/or the Department of Health and Welfare if there's a medical issue, if they think that there is an issue for a particular child. They may become involved in that circumstance. You can then tap into 161627. The department isn't restricted from trying to access treatment for a child under that provision if there are no other basis to find neglect or abuse or whatever it might be. So the Department of Health and Welfare would be involved in that circumstance, but in order to activate 161627, someone needs to know about the child.
Ms. Pike, did you say you were going to address Title 18 also?
No, I do not, and it was my understanding I was just to speak to the Child Protective Act.
Senator Schmidt?
Sorry, Mr. Chairman, but a follow-up, and now that we've gotten into mandatory reporting, which is 161605, I look at 161605 sub 2, and ordained minister of a religion, I think is also required to report. Is that correct?
Ms. Pike?
Mr. Chairman, Senator Schmidt, basically, if there is, for purposes of subsection 3, basically what it says, a duly ordained minister of a religion is defined in that statute. And so if, let me go back here.
If it's in confession, no. But if it's not in confession, they are required.
Basically, if an individual who meets the definition under subsection 2, they could basically opt out as being a mandatory reporter. If they are a duly ordained minister of religion, and that's defined as someone who has been ordained or set apart in accordance with ceremonial, ritual, or discipline of a church or religious organization, which have been established on the basis of a community religious faith, belief, doctrines, and practices. To hear confessions and confidential communications in accordance with the bona fide doctrines of that religion. Just because you have a conversation with church members, it doesn't necessarily fall under that. So it has to meet this definition, and then that person is not obligated to report. I guess one view of it would be if you go into confession to your priest and make your confession, he does not disclose.
Follow-up clarification.
Senator Schmidt?
And I agree with that interpretation, but my interpretation of the statute sub 2, sub 3 would be that if a ordained minister does have direct knowledge of neglect or abuse, they are required to report. And maybe I'm reading it wrong, and I read statute wrong all the time, but and so I'd appreciate your help clarifying that.
Ms. Pike?
Chairman Johnson, Senator Schmidt, the notification requirements do not apply to a duly ordained minister with regard to confession or confidential communication in the course of discipline to which he brings, and he has to meet the requirements of A, B, and C. If he meets those requirements, he does not have to report.
Again, Mr. Chairman, just as follow-up,
Senator Jones,
you stated what I stated, which is in confession or confidential communication, but I stated direct knowledge. If the ordained minister has direct knowledge, they are required to report. That's how I read that statute.
Ms. Pike?
Mr. Chairman, Senator Schmidt, basically what it says, that the confession or confidential communication was made in a manner context which places the duly ordained minister of religion specifically and strictly under a level of confidentiality that is considered inviolate by canon law or church doctrine. A confession or confidential communication made under any other circumstance does not fall within that. So when you're looking at general knowledge, something outside of the confessional, then yes, they would have to report. They would have to report. And I apologize if I confused you. I was thinking more of, the ordained minister and the confidentiality piece.
Thank you, Ms. Feig. Committee, any other questions? Thank you, Ms. Feig, for being here today. And Ms. McKay, I'm sure at some future time we're going to have to address Title 18 and maybe how those two titles are tied together or not through the exemption. So
Certainly.
thank you for being here today. Okay, next we will call up Roxanne Prince. Welcome, Roxanne to Boise from the Department of Health and Welfare. She's going to discuss the department's role in child protection and faith healing. I had the pleasure of meeting with Roxanne a couple of weeks ago, and so I'm looking forward to your presentation. And again, when you address the committee, if you could work through the chair and then recognize the legislator asking the question, that would be wonderful. And speak into the microphone, identify yourself, who you work for, your purpose for being here, and the floor is yours. Thank you, Ms. Prince.
Thank you, Senator Johnson and Representative Palmer. My name is Roxanne Prince, and I am the Child Welfare Program Manager for the 10 northern counties. And so I'm responsible for budget, personnel, and clinical direction for those counties. Typically, I don't have the pleasure of coming to these forums, but I believe I was asked to do that today because I have over 20 years of child welfare experience, and that I have also have on the ground experience in addressing, I believe, the matter that's being discussed today. And so for preparation for this, I did, we don't keep track of these particular cases in terms of our data system, but we do anecdotally, they are obviously unique. And so I was able to research and review the record for 5 cases, 3 of which I was the direct supervisor on those cases, and then was also able to talk to workers and current supervisors who are in the field today who respond to these calls. So that's the context about why I am here. Senator Johnson and Representative Palmer, would you allow the committee to have a handout?
That would be great. Thank you, Ms. Prince. If Ryan, could you get those for the committee? Thank you.
And Mr. Chairman, could we ask Ms. Prince to speak up a little bit?
Thank you, Senator Schmidt. We have folks at home listening, and I've done that many times myself, and it is kind of hard to hear sometimes. So if you can, just enunciate the words and project your voice. Get up close to that microphone, because we want to make sure that everybody is well informed, including those in the audience here today, so that we can capture everything that's said. Thank you.
Thank you, Chairman and committee members. That's often the feedback I get, so I'll try to remember that for sure. So what I gave you is a very simple flow chart of our child protection business flow, and it just serves as kind of a guide so that it can let you know where I'm at in the process. And so I do want to thank my legal colleagues, Mary Jo Beige and Nicole McKay, because they've taken care of the legal definitions for you. And so here is the process of how it looks in the field. So as mentioned, our involvement starts with a referral, typically from the community. So that is friends, family, neighbors, professional entities such as schools, hospitals, doctors, who have a particular concern regarding the child, and they call into our centralized intake line. In 2012, we have one phone line that community members can call into and express their concern. In 2015, we did receive about 22,000 calls, and out of those, we did respond to about 8,500 of those calls. And though we're not able to pinpoint exactly how many were neglect, specifically medical neglect, half of those were coded as neglect. So with that, those are reviewed and then prioritized. So the priority system goes very simply that priority ones we need to respond to right away, and that those are concerns regarding life-threatening physical abuse, life-threatening physical or medical neglect, sexual abuse where the child has direct contact with the alleged perpetrator. Our priority 2, referrals are responded to within 24 hours, and we see the children within 48 hours, and that includes non-life-threatening physical and medical neglect, sexual abuse where the child does not have immediate contact with the alleged offender, and non-life-threatening physical abuse. And then we have a priority 3, which we need to respond within 72 hours and see the child within 5 days. And that is, and those concerns are regarding supervision, hazardous home environment, or moderate medical neglect. So once those are prioritized, the supervisor reviews the circumstances of the case, and I would clarify that regardless of whether there's a religious factor to whether medical attention is sought or not, we still are prioritizing those referrals, and we do approach families. And so once we get into a family, we do respond on priority 1s and 2s with law enforcement, because we are the civil action and they are the criminal component. And so they'll be doing their own separate investigation as well. So they do accompany us a lot of times on home visits. And so we approach a family and we talk to them about the concerns, and we ask to interview the child alone. In these particular incidents, where there is a faith exemption claim, again, we are not medical personnel, we are social workers, and so we do indeed need the court to intervene in terms of treatment or assessment of a child's medical needs. And so how that looks is, if it isn't immediate, we do work with our local prosecutors. We talk with the family. Oftentimes they do know what the process is. They know what the law is. They have consulted with their church family, the elders. And at that point, again, if it's not, it might be urgent but not immediate, we do have a summons for court. Typically either that day or the next day. Upon that, the judge can review our concerns and listen to the concerns of the family, and then he or she can certainly order either a medical assessment or medical treatment as deemed necessary by a doctor. And at that point, if a judge does order that, then what we have found is that families have complied with that, and then those findings from the doctor are reported back to the court, and then it proceeds from there in terms of whether or not treatment is pursued, or whether the family is allowed to go back to using their faith means of treating their children. And then, per what the former presentation said, is we do have 30 days to make a determination of, in this case, neglect, substantiation or unsubstantiation. And if that is the only concern we have is not treating children because of their religious beliefs, then it is disposition, the case's disposition is unsubstantiated. So that's a brief overview. I do have specifics in terms of not identifying specific cases, but just nuances and themes, but I will let that be up to the Senator Johnson and Representative Palmer and the committee members to ask as fits their needs.
Senator Hagedorn.
Thank you, Mr. Chairman. Thank you, Ms. Prince, for walking us through that. I appreciate that. And I'm wondering, where are abuse, neglect, and abandonment defined and the different levels for the health and welfare social workers when they get these calls? Is that in statute?
Yes.
Is it in rule? Or could you?
We do have statute.
Ms.
and then
Prince?
yeah, oh, I'm sorry. Thank you, Chairman, for the reminder, and Senator Hagedorn. We do have, what we have is the process of statute that then, of course, gets made into rules, and then we have a standard of practice, which is easily accessed, and so we refer to our standard of practice, and though we wish it was an exact science, a lot of times the information that we get to us from community members is sometimes not always well defined, and so we always want to err on the side of safety. And so if their concern is brought forth, we need to ask questions about the extent of the neglect. What's the age of the child? What state of well-being did they see them last? And so on that information, we're able to discern whether or not it should be prioritized as a 1, 2, or 3.
Follow up, Mr. Chairman.
Senator Hagedorn.
Thank you, Mr. Chairman. Ms. Prince, is that standard of practice a public document?
Thank you, Mr. Chairman, and Senator Hagedorn. Yes, it is. It is found on the Idaho Child Welfare website under Children and then Standards, and it is the prioritization standard. It is
Thank you.
public.
Senator Schmidt.
Thank you, Mr. Chairman. Ms. Prince, you described, now I might have gotten the numbers wrong, I was listening. I think you said there were 22,000 reported, 8,500 were investigated. Could you describe the numbers of priority 1, 2, and 3 among that 8,500?
Ms. Prince.
Yes, Chairman, thank you, and Senator Schmidt. I'm going to refer to my stat book. You would think I would have those memorized, but I don't. I'm sorry, I don't have that right at my fingertips. I do have, the numbers in terms of the majority of the referrals in terms of not necessarily percentage, but for instance, informational referrals were 11,000, neglect were the 4,000, sexual abuse was about 500, and physical abuse was about 2,500. And so, though I could certainly get that for the committee, that would be easy to do.
Just as a request, Mr. Chairman, because my impression, so I served on a multidisciplinary team in my county where we reviewed these referrals, and we'd have, in a 2-month period, a couple hundred referrals, and maybe 1 or 2 were category 1. So it was a very low frequency of a severe risk. At least that was my impression. And I was wondering if that was true statewide. And you could help us with that. Thank you.
Thank you, Senator Schmidt. Ms. Prince, also, if you would submit that information to LSO, to Mr. Bush or Mr. Hoskins, that would be great. And they'll make sure that the committee gets it. So when you gather that information and you identify by the different priorities, are you also able to distinguish in those the different types of neglect?
No, and that is Chairman, and we have not. What we were able to distinguish is out of 4,000, approximately 4,000 substantiations, we did know last year that we had 13 substantiation for medical neglect. Now, if that, I don't know if there's any specifics in terms of whether that had to do with religious exemption or not. We weren't able to tease that out. For reference, I did find my percentage page, if that would be of help.
Please, Ms. Prince.
Thank you, Chairman. And to answer your question, Senator Schmidt, so what we have out of those 22,000, we do have 25% of those are priority ones, 15% are priority twos, and 60% are priority threes. And I'm happy to leave this here for further reference if that's needed.
Thank you, Ms. Prince. Representative Harris.
Well, thank you, Chairman. You mentioned you might have some anecdotal examples of how this has played out, where the religious exemption was used. Can you share some of that with us and give us a flavor for how those worked in the end?
Thank
Ms.
you.
Prince.
Thank you, Chairman and Representative Harris. Yeah, so when I took a look at the themes and went back in terms when I was practicing, we had a few cases in which they were community referrals and had concerns about just generally around the condition of a child, sickly. And so we did approach the family, and I do want to put out there that the theme is when child protection enters a home, there's a lot of different reactions that happen. It's sometimes a very scary process. What we have found is these families definitely open the door for us, let us come in, interview their children. They, like I said, they do know the law. They do consult with their elders, and then they have, on 3 occasions, we did ask for a summons, and then on those 3 occasions, the judge did order not treatment, but he did order a medical exam to diagnose the child and see what the medical condition was. I would put out there again, you know, when you're asking a family to do that, when that is not their belief system, it is very foreign to them about hospitals, insurance, how to pay for that. And so as health and welfare, as a safety assessor, and working with the family, working through those issues around, at times on one case we did pay, on another case the doctor did pro bono, and then on another case the church family did help the family with those expenses. On all 3 cases, the diagnosis of the child was at that point terminal, and so when we went back to the judge, there was a determination that there was no need for future treatment, because at that point the child was eventually going to die, and there was nothing medically that could be done. And so we were dismissed and closed our case, and again, those cases were unsubstantiated. We did have an example that maybe could answer a question, in that we were called in due to lack of medical care, but what we found out in the process is that the injuries that the child sustained were indeed inflicted by the parent. And so at that point, though we definitely wanted to work with the medical or the belief system of the family, we had a broader issue to consider, and we did have to take that child into care. And even then, when we have shelter care in that first 2 days, we do not have, the health and welfare does not have medical authority, and so a judge does have to order that, as well as even when we get temporary custody before the shelter care hearing as well. And so on that particular case, we were needing to make a service plan with that family. We were needing to work on not only making sure that the child was within getting that medical care to the point that she was going to be okay, but we needed to work on the disciplinary actions of the parent and how that child was overall cared for. And then the final, I think, theme is that we did have a certain example that was more immediate, and that we had a child who had a broken bone, and the parents did claim the faith exemption, did allow their child to go immediately to the hospital. Doctor said, you know, it's not going to be easy, but there's no infection, and done deal. And we did consult with the prosecutor on that situation, and given the doctor's bill of health of, granted, probably it will not grow appropriately, but at the same time, the child will be okay and will probably be in a lot of pain. With collaboration with the prosecutor, we did allow the family to practice their healing beliefs, and we closed our case unsubstantiated.
Representative Harris?
Thank you, Chairman. In those cases where the children were terminally ill, and perhaps due to lack of prior attention, were there charges of neglect against the parents, or could there have been?
Ms. Prince?
Chairman, Representative Harris, you know, at that point, again, I represent more of the hands-on piece of it, so no charges were not brought against the family. And again, maybe other social workers do it differently, but I think when we look at it and we hear that a child is terminally ill, and at that point, the question isn't coulda, shoulda, woulda. It really is about go home and take care of your child. And again, I'm just speaking from a practitioner in trying to be humane and working with families. So no, there were no charges. And nor do I believe that we looked further into it with doctors to ask that question of what could have been prevented.
Thank you for your compassion, Ms. Prince. Representative Trujillo?
Thank you, Mr. Chairman. I'm curious, as a practitioner, if you believe the statutes as written actually provide the coverage needed for the children.
Ms. Prince, I don't know if I'm going to let you answer that question. Ms. McKay, if you'd please come up to the microphone, please, and introduce yourself and give us your thoughts on that.
I appreciate that, Senator Johnson. I couldn't get up fast enough. The Department of Health and Welfare and the Attorney General's Office are happy to provide any information about the current state of practice or the current state of the law. It is a policy decision that is best left up to your body to determine whether or not changes need to be made to the law. We can only tell you how the current state of the law is being implemented. I apologize.
Ms. Trujillo? Or, pardon me, Representative Trujillo. I'll pay for that later.
Thank you, Mr. Chairman. Just a quick follow-up. So from a practitioner standpoint, these children were actually protected by the state. Is that an accurate statement?
Ms. McKay?
Mr. Chairman, Representative Trujillo, I'm not sure I understand the question. Could I ask you to rephrase that?
Representative Trujillo?
Mr. Chairman, thank you. When it comes to medical decisions, the state did their job in protecting these children so that there was no imminent harm to these children in these situations. Is that correct?
Ms. McKay?
Mr. Chairman and Representative Trujillo, I don't think that I can conclude that the state was able to protect these children. The state is only able to do what is statutorily authorized, and in these situations, if it comes to the attention of the state that there is a child with a potentially life-threatening situation, we have particular processes that we can implement, that being, if it comes to the attention of, say, the department, we can petition or call the prosecutor to petition for this emergency physical medical evaluation. If it's not if it does not come to the attention of the department or the state, then no, we are not able to intervene in protecting the safety, health, or welfare of the child.
Representative Kaufman.
Thank you, Mr. Chairman. Ms. Prince, on some numbers you gave earlier, I want to make sure I got these right. Did you say there was 13 out of 4,000 incidents that were medical neglect?
Ms. Prince.
Chairman, Representative Kaufman, for clarification, out of 4,000 substantiations where we actually went out and substantiated, 13 of those in 2015 were medical neglect. And again, we are not able to discern whether or not that had the religious exemption attached to it.
Thank you.
Thank you.
Representative Gannon.
Thank you, Mr. Chairman. And I was wondering if either presenter might be able to give us an idea of how long the process takes if you became aware of a medical condition that was endangering the child, for example, acute appendicitis, something like that. How long does it take to go through the process of going through to petitioning the court and having the hearing, et cetera?
Ms. Prince.
Chairman, Representative Gannon. So it was interesting, I was looking through there that we've always had an opportunity to go ahead and staff with a prosecutor, get an order, and we have been able to get into court quite readily, like the next day. There are times where, whether it's an absent parent and this religion doesn't factor into it, or if there is a religious exemption when there's immediacy, we are able to staff over the phone with the prosecutor and get a verbal order from a judge immediately. So that really goes for when there's for some reason a parent is not available to consent, and yet there's immediate need. We do have that ability to do that.
Representative Gannon.
Thank you, Mr. Chairman and Ms. Prince. So if there was no opposition, in other words, no parent available to consent, you could do it fairly immediately. But if there was opposition, parent didn't wish to proceed, it could take, what, a day or two? Or
Ms. Prince.
Chairman, Representative Gannon, I don't know that it's about wishes of a parent. I think it really has to do to the immediacy of what a doctor is saying that a child needs. And so we will take that language, even have the doctor talk with the prosecutor, and then the judge has to weigh in whether it's an absent parent, whether there's a religious component, and again, they make the decision, and they can do that within, again, I haven't, within moments. So I haven't had the experience where that has had the religion exemption component to it. I have had it when there is a parent who is unavailable to consent to treatment, and it's been 10 minutes and the situation is outlined, and the judge has given a verbal order for treatment.
Senator Schmidt.
Thank you, Mr. Chairman. Ms. Prince, you described cases in which there was an intervention by the department and then the medical examination and the children found to be terminal. I know how this would be looked at in my county, but I'm wondering, are you aware of if the prosecuting attorney in this county was aware of these cases?
Ms. Prince.
Thank you, Chairman. Senator Schmidt. Yes, they are a part of that process. We initially have to staff with the prosecutor in terms of our Child Protection Act, and so, yes, they were.
Thank you.
Senator Hagedorn.
Thank you, Mr. Chairman. Ms. Prince, you said you had 22,000 reports called in, 8,500 were investigated. Do you have a feel for how many of those that were investigated that the folks used the religious exemption to protect their child through faith?
Ms. Prince.
Thank you, Chairman. Senator Hagedorn. Quite simply, the answer is no, because I do believe that, Again, we do not specifically track medical neglect with the exemption. And so what I gave you today is purely, again, they definitely are unique situations and so memorable. And so what I was able to give you today was anecdotal based on my prior practicing, and then also a query statewide of my colleagues to say what cases have surfaced recently. And so what I was able to gather just on that very informal inquiry was about 5 cases.
Say that.
It was about 5 situations. Yeah.
Senator Hagedorn.
Thank you, Mr. Chairman. In your 20 years, in your experience, how many cases have you personally taken care of? And how many cases do you recall of that religious exemption being used?
Ms. Prince.
Thank you, Chairman. Senator Hagedorn. 3. The 3 that I spoke to were the 3 that I have been involved in.
Okay, thank you.
Committee, any further questions? Seeing none, thank you, Ms. Prince, for being here today and for sharing with us. We appreciate your efforts in this. And Ms. McKay and Ms. Beig, everyone for being here from Office of Attorney General, Department of Health and Welfare. Thank you. Next up, we have Gene Fisher from the Ada County Prosecutor's Office, a Special Crimes Unit Chief. Welcome. Ms. Fisher, and for the record, if you'd please state your name, who you represent, your purpose for being here. And also as a reminder, we do have folks at home listening. If you could speak clearly, loudly into the microphone so they can hear and we can hear. The floor is yours, and welcome.
Thank you. Good morning, Chairman Johnson, members of the committee. Thank you for having me here. My name is Gene Fisher. I am a deputy prosecutor for Ada County and have been in this position for 26 years. I'm the Special Crimes Unit Chief for Ada County and have been running the Ada County Prosecutor's Special Crimes Unit for 20-some years now. I'm also here on behalf of the Idaho Prosecuting Attorneys Association, and I'm speaking on their behalf. This issue, I've been listening very carefully to your questions, and this issue is really very complicated because we're dealing obviously with the lives of families and children, and we have very different problems because on one level, we're talking about the lives of children and their medical needs, and then we're framing it against the rights of parents and their religious needs, and those do not always go together. The questions that have been asked here about what does 18-1501 do criminally versus talking about the child protection, there are very different standards and there's some different legal obligations and standards to look at, but we really do have to look at them together. I can tell you from my experience in the Ada County Prosecutor's Office, I have in the last year, I have had 3 cases that have come to me under this provision of faith-based medical neglect. 2 were legitimate. 1 was not legitimate. However, that mother tried to use a faith-based exception to preventing her son from getting chemotherapy. He was 16 years old. It was imminently treatable. She worked the system hard, and by the time it got in front of the court, and the court then brought the 16-year-old in because the court can order medical treatment, but now you're talking about a 16-year-old, and how do you make a child sit through chemotherapy, and how do you make that happen if there's been issues of neglect or if the mother has not done something to hurt that child? And he ultimately accepted the court's order, but it was too late and he died. And it was imminently treatable. I've had another case this year. So I tell you this because although I am the criminal prosecutor, in our office and in many offices across the state, you have the criminal prosecutor who works on the criminal aspect of child issues, and then you have a child protection who's working with health and welfare. And a lot of these things obviously cross over. In our jurisdiction, we meet regularly, and I run the MDT, which Senator Schmidt had talked about, where we have members from CARES, Health and Welfare, Law Enforcement, and Prosecutor's Office there weekly to discuss cases that have come up that are of particular trouble or troublesome issues. And so I get those cases, and we staff them and help direct investigations and how to get things moving sometimes. The problem is that in many of these cases, or several of these cases, those aren't the cases that are coming to the MDT because the faith base is within their own community. And that community believes that they have the ability to pray or have faith base, and so they are not reporting. So an entire community is not reporting. And there's mandatory reporting, but an entire community doesn't report because they all believe the same thing. So in this instance that we had just recently, we have two cases to tell you a little bit of differences between the two, and I think they're helpful for you. One was a young third grader who had been homeschooled for a significant period of time. A decision was finally made by her parents to put her in public school, and mom worked at the public school. The school was happy to have them there. They knew of her faith base, and they were working with her, but the child was very sick, and she was having seizures all the time. And it got to the point where she would have seizures, and then mom would work and come and take her child and just take her home. And then they wouldn't bring her back for a couple of weeks, and then the child would be back in school, and the teachers were glad to have her back, and she would have seizures in class. She fell, she hit her head. By the time we got the case, the school brought it to our attention. That child was having 13 seizures a day. She was very, very ill, and she was 8, and she was suffering terribly. And everybody else around her was suffering because you had to watch that. That case ultimately came, we collected all of the medical evidence, and then our CP prosecutor took that in front of the court and with a medical doctor from St. Luke's, from our CARES unit, presented evidence that this child needs emergency medical attention. The family was very cooperative. Their faith was that they believed in prayer, but if the law said they had to do this, they would do it. So they were looking for a law to get them to do it. The judge ordered it. They complied. The child went and saw a neurologist. They put her on one medicine, it didn't work. They put her on a second medicine, it worked. No more seizures. But she suffered a long time. And the case did not go back to the front of Health and Welfare. She stayed at home. There was not an issue of neglect otherwise, other than this medical issue with faith base. And so Health and Welfare's role in that was really very minimal, in fact, no role at all, other than the child protection prosecutor who took that case into court. There were no other issues in this family, and the case was resolved. But it required a lot of attention from schools, the prosecutors, doctors, to bring all of this information together and then take it to the court. It doesn't happen in a day. These things take a time. The doctors have to look at it and review it. We've got to get information from law enforcement. In this case, was investigating because they were saying it was faith-based, but we needed to go to court and be able to prove that, and so we have to look at everything. The father in this case wore glasses. Mom goes to the dentist. Is it all faith-based? Or just what applies to your child? Faith-based didn't cure his sight, and he could wear glasses. It doesn't cure her cavities, so she went to a dentist. But it was faith-based as it related to this child. So I'm asking you to look at this from a different perspective because I think that this is about the rights of children. When we're here now in the 21st century, I think that we should be looking at the rights of children because children are not chattel anymore. Children are not property. And we have to, and I think we need to respect that. Our state has long agreed that we need to protect our most vulnerable. And we have a good law in the books talking about protecting children from people who harm them when they cannot protect themselves. So when we started this conversation about rights of parents, I'd also like to sort of turn the conversation about rights of children. because these children are suffering at the expense sometimes of their parents. And it's not that easy to get them help. In the second case that we had, it actually ended up in Canyon County, but I'm very familiar with the facts in it. A young child had a terrible heart defect. She was going to school. The school knew she had a heart defect. She had limited PE, limited activity at school. It got to the point where her lips were blue, her fingernails were blue. She was very, very ill and weak. By the time that case got, and she suffered a long time with this, by the time the case got to CARES and law enforcement's attention, the investigation took place. It was a family of faith that thought they could do this by prayer. When she went in, her oxygen was at 60%. The judge ordered diagnostics and testing. She went to a cardiologist, and the cardiologist said, if this had been caught at an earlier time, it was imminently treatable, but her systems had been so affected by this now that there was nothing they could do, and that she was going to die, and that she would fight for breath for her very last day. And she was 8 years old, and there was nothing you could do about it. The case is tragic. And that's a child, and yes, it's a child of, with obviously some parents, but we have to be looking at, I think, this sometimes about the rights of children. And it's not that easy to take these cases in front of courts. Judges also struggle with this. They are not medical doctors. And so when we bring these cases to them, we have to have a lot of information. We have to have all the medical there, and they have to explain it to them so that they can understand it. And then they realize that they are going to make a really significant decision under the present state of the law requiring medical attention. However, like as I said, when I started this, if it goes on for so long, the reality is that you're working with a 14-year-old, a 15-year-old, 16-year-old who's been living in this situation and living with the idea of faith, and then you order medical. It's only as good sometimes as the child's going to allow that to happen, because at that point they're pretty willful, and they've got some of their ideas of their own, and they love their parents very much, and their parents love them very much, and they don't want to disappoint. And it's a huge issue. So it's a little more complicated sometimes in the practicality of how this works. You asked about how 18-1501 works. That statute is a difficult statute to work with. Our felony injury to child statute was modeled after California, and for a practitioner, I think our statute is really difficult to prosecute under this. However, the exception is if we were to look at charging a parent under medical neglect, we would have to look under the exception under 18-1501 that says that a parent or a caregiver, in this case a parent, who permits their child to suffer that could cause great bodily harm. And so that's really what you're looking under. We're not looking at a parent who is causing the harm. We're not looking at a parent in this instance who, which we've had before. We've had a lot of parents who come who say that they love their child, and that their faith allows them to hit and strike and take, get rid of sin by physical abuse. And that has been their defense. Sometimes it has swayed juries, and sometimes not. So each case really we have to evaluate it very differently. In the medical abuse situation that we're talking about with faith-based, it's going to be looking at it, does a parent permit a child to suffer this great bodily harm without getting them the medical attention that they need? The problem is that while the law sounds fine, the fact of the matter is we have this faith-based exception, And so it still allows a parent, it doesn't stop me from charging, but it's a hurdle, because it does allow a parent to come in and talk about their faith, and the law actually says, we have an exception. And if a jury says, yeah, you're right, the exception is right there, they're not going to be, the likelihood of conviction is very low. And so we don't take very many of those cases because we have to review that carefully. So in my experience, faith-based alone, they are not getting charged. Now, if there's something other underneath that or different, or their idea of faith-based is not complemented with their lifestyle, and we can show that it's not, then we could make a good case for it. But if it truly is the family with the child who needed medical attention for the neurology issue that she had, and she had her medicine, we're not going to charge that case. That is a case that Child Protection needs to take care of. They did take care of it through court, and the case was dismissed, and that's the end of it. So as I appear here today for you from the Idaho Prosecuting Attorneys Association and my own professional practice, we would like to see this exemption lifted. It is a very difficult, it's not going to change the practice. If somebody is not getting their child medical attention, the same process is going to take place. We're still going to have to go through the court to order this. I mean, that's all still going to have to happen. But it does change the nature sometimes of looking at a case, whether or not some other case should be filed criminally or not. More importantly, I just think it's the wrong message, because I don't think that the rights of a parent should so supersede the medical needs of a child. And that these children need, I mean, if the state says that we are going to protect our most vulnerable, and we have laws that do that, then why would we allow this exception, and knowing that these children are suffering, and they're really, truly suffering, and they don't need to be, until it's sometimes too late. And that, to me, is just too much, it's just too expensive, and is unjust. When it comes to the rights of these children and the rights of our, just to be a human being and to have your dignity and to be able to have health when your medical community could take care of you, but your parents believe that faith will cure you. So we'd like to see that exemption lifted. And I'll stand for any questions.
Thank you, Ms. Fisher. Senator Hagedorn.
Thank you, Mr. Chairman. Thank you, Ms. Fisher. I'm breaking this issue down into two different categories in my little brain here. One is child protection and the faith-based exemption for child protection. And the other is criminal investigations and prosecution and faith-based protections within that realm. And I'm wondering if our child protection services and our criminal investigation services, how strong is that link in communications around the state? And I understand you could probably just speak for Ada County, but in other parts of the state, do we have good connectivity there between law enforcement and child protective services?
Senator Johnson, Senator Hagedorn, I don't know if I can answer that statewide. I am familiar with the bigger counties. I advise the big counties all the time, on MDT, about multidisciplinary teams and how to handle these cases. And I know counties like Twin Falls, Coeur d'Alene, Canyon County, Pocatello. I mean, I know the bigger counties are staffing these cases and are conducting MDTs much like we would do with regular meetings with health and welfare and law enforcement. So I know that from the bigger, those are the ones that I hear from. Whether that is happening in the smaller counties, I don't know. The reality in some of these experiences, though, is that, some of the counties are so small that the prosecutor who does the criminal case is the same prosecutor who does the child protection case, because that's the only prosecutor that they have. And so they are doing both at the same time and trying to weigh the differences between, am I going to just do criminally, or am I going to do civilly? In Ada County and some of the bigger counties, we have purposely sort of walled off, if you will, the ability for the criminal prosecutor to really talk about the civil proceedings and child protection, because those are supposed to be closed proceedings. The reality is that we obviously hear about these cases because we're talking at MDT and we're developing cases, and I'm helping with that. But we have a much more, the bigger counties, I think, have a much more divisive system just between just those two, because child protection is supposed to be closed, and we're not supposed to be using what we know in child protection over here in criminal. So it's complicated, and I don't know if I've answered your question exactly, but these are, they are complicated investigations. What I can tell you is that we do need to rely on law enforcement to do a lot of the investigations. While I appreciate that health and welfare has investigators and they will do this, they often don't do it alone. These cases usually come from a referral to law enforcement that gets reported to health and welfare, and they might do a joint investigation and get information together. But I don't see that health and welfare is just doing this on their own.
One follow-up.
Senator Hagedorn.
Thank you, Mr. Chairman. Do you have an idea of how often people are prosecuted for not reporting, specifically in faith-based?
Oh, specifically in
Ms.
faith-based,
Fisher.
excuse me. Senator Johnson, statewide, I don't have, in talking with the other prosecutors, because of the faith-based exception, I don't believe that we've actually had any prosecutions for failing to report, because there clearly is an exception in the law. And you can't report on something if you don't believe that you've done something either wrong or neglectful, because that's sort of incumbent. The law says if you believe a child is subject to great, abuse or neglect, you have to report. But self-reporting, or like I said, this whole community, in some places, the whole community are not reporting because they all believe the same thing. We're all doing faith-based together, and we think that we don't have to report. But I don't believe that there's been any prosecutions for failing to report in faith-based.
Thank you.
Certainly not in my 26 years.
Senator Sidaway.
Thank you, Mr. Chairman. Ms. Fisher, in your example of the 16-year-old boy that died from cancer, were his parents practicing a faith-based healing?
Senator Johnson,
Yes,
Senator Sidaway, initially she said she was, but when law enforcement then investigated that, they quickly figured it out that she really wasn't doing that at all. And it became very complicated. The court still ordered the treatment. There was initially some resistance to that, and then ultimately the child did start the chemotherapy, but like I said, it was too late. That case did come to us for consideration for criminal charges, and we declined to prosecute. There were a lot of other reasons in that case. She ultimately lost her son as well, but there were lots of other reasons, and that case was not prosecuted.
Okay, and the
Senator
follow-up,
Sidaway.
and you probably just answered my follow-up question. It sounds like there were charges filed. There were not charges filed?
There were no criminal charges filed.
Okay. Could you explain why why there were no criminal charges filed for neglect, I guess.
Ms. Fisher.
Senator Johnson, Senator Sidaway, while we did have the issues of neglect, when it came down to the actual medical testimony and expertise that we were going to require, there was questions, medical questions and concerns, as I recall, about how that testimony would come out as far as the lingering of the cancer versus how fast it took off, that there were some just honest questions about cancer in and of itself, if she had there was just timeline problems with it. And it appeared to me that we may have a battle of the experts when it comes to just about the cancer itself and the probable cause of the neglect versus the cancer just sort of taking off on him. And the decision ultimately was made that, while tragic, we couldn't prove that case beyond a reasonable doubt.
So one more, please, Mr.
Senator
Chairman.
Sidaway.
Thank you. So in this case that used as an example, it sounded like the investigation determined that she was not a faith-based, and I guess, so do you find that often? Do you get into the where someone's looking for an exemption, or are the attorneys that are representing these folks putting that on the table? And it doesn't sound like there are very many cases at all, but the few that do come to your attention or get placed in front of you, is that argument made that these are faith-based? And if that argument is made, and the investigation to delves into that, do they find that a lot of those cases in reality are not faith-based? They're just using that as an excuse for that, to try to get that exemption?
Ms. Fisher.
Senator Johnson, the question is a little more complicated when it comes out to the scenarios that I have had to work with. So I have more often seen a parent who's actually causing physical abuse try to use faith as the reason. My faith, my child is doing something that my faith does not agree with, and I am using corporal punishment in order to correct their behavior. And because I believe in my faith, and my faith allows me to use corporal punishment, I believe that what I did was right, and I have not been neglectful. So you have that side of things that are sometimes that we have to ferret through, and take those cases to juries, and juries have to decide how sincerely do they believe that, how bad is the abuse, and what was the behavior of the child. And it pits behaviors of children against wishes of parents, and you never know what a jury is going to do. I've had very mixed results from that. So there's that aspect of it. The medical aspect, the medical abuse aspect, we're still faith-based, but now we're not getting anybody treatment. We're not doing it because spiritually we believe that prayer alone will do this. In those instances, it's not that we're investigating it, that just comes up. I mean, it's just the parents are the ones that generally assert that. And when they assert it, it becomes clear pretty fast whether or not that is truly their religion. And you can see it because law enforcement's investigating it, and no one's doubting that this is their faith. I mean, in the instance, the two other instances with the children with the heart defect and the scarring on her brain, they truly were faith-based. I mean, nobody was denying that. And they truly believed, I think law enforcement said they were cooperative, they had, they had great homes, there was no other issue of neglect, except for this medical issue where their children were suffering a great deal and could have been treated much simpler and much faster if they had gotten the medical help. So when we look at those cases, we have to, we look at those carefully, given the exception that is there on the books for faith-based healing, it would be very difficult for a prosecutor to then prosecute criminally when there is an exception right there that says, but my faith alone allows me to go about this my way. I think you're just asking for a jury to nullify. You can't get 12 to agree when you've got two laws that are contradictory.
Representative Kaufman.
Thank you, Mr. Chairman. Ms. Fisher, earlier, did you say or imply that if the exemption was lifted, that the only difference would be that it would be easier to prosecute? Because you said we'd have to go through the same process. So if the exemption is lifted, does it just make it easier to prosecute? Is that what you said or implied?
Ms. Fisher.
Senator Johnson, I didn't mean to infer that it would be easier to prosecute. If somebody it was not faith-based, they're just not getting their child medical care, or they don't believe that that their child needs medical care, but it's not particularly rooted in faith. They just don't believe it. They don't believe in the medicine. They don't believe in the science. It's not faith-based. I don't like doctors. We'd have to do the exact same process to get to court to order the medical treatment. In the criminal aspect of it, we would have to look at what is it about their attitudes that say we just don't believe in doctors, or we just don't believe in the chemicals that are involved in chemotherapy, and we really just want it to be immunotherapy only, or we want it to be vitamin only because I believe that I'm holistic and I just want vitamins, and I'm not being neglectful. That's what I believe, and I'm the parent. So in that instance, we may still have the same difficult decision about the criminal prosecution and their intent. Because if we do an investigation and ultimately conclude that they legitimately, honestly believe that vitamins are going to cure this versus chemotherapy, it's a very difficult case to prosecute, but it's a perfect case for child protection to get involved in. It's a perfect case for the child protection court to be involved and to make sure that a child gets treatment and to have follow-up with health and welfare to make sure that the parents are following the child protection court order to get treatment. We had a huge case several years ago where mom had a child in Salt Lake City. She believed in vitamin therapy only for her child that had cancer, and the court ordered it, and she just didn't believe it. And I don't know if you remember this case, but she came to Idaho, and they were all looking for this child who had cancer, who needed this treatment right away. I mean, she really believed that vitamins and holistic was going to do it. It had nothing to do with her faith. It was just her other belief. So you have to go through the same exercise. Is this a case that we would be able to prosecute? Did she have intent to hurt her child, or is her whole life about holistic, natural, vitamin way of life? And so is the intent there. So it's going to be the same question. It's not just faith-based that this necessarily affects.
Representative Gannon.
Thank you, Mr. Chairman. And Ms. Fisher, I wanted to go back to an earlier statement you made about you had a case where there was a ruling and the family then followed the law and did what the court recommended or told them to do. And I'm thinking, we've been talking about prosecutions, but isn't one of the purposes of our criminal statutes really to influence conduct and to deter conduct? It's not really the criminal statutes aren't really there so that we to give business to the prosecutors. It's really there to is really there to set forth public policy and to deter, to set forth what the social or public policy should be. And I'm wondering if you could comment on that, and if we did have a change, maybe, that we're not looking so much at prosecutions, but we're more looking at a change in influencing decision-making.
Ms. Fisher.
Senator Johnson, that's a hard question. I mean, clearly the law, we have laws we have laws to protect children because we've decided as a state that there are certain things that, children need protection from. And those laws, within those laws, I think that, and then we also have just our social norms about what is criminal conduct and what's not. In the CP case, in the CP court case, with some of these cases, I get cases to review sometimes where they want me to look at it for criminal charges, and there's also a child protection issue going on at the same time. And there are many, many instances when the conclusion that I make is this is a case for child protection, and the court's child protection court to work with the family and health and welfare to work with the family. This is not a case about criminal involvement, and I decline those cases regularly and say this matter is being handled by the child protection court because there's no other issue of abuse except for this medical neglect issue. So the problem is that in the one instance, the family was very receptive. Once the court ordered it, they said essentially they had a moral obligation to follow the law, and that they were not going to violate the law. They had a moral, they had a moral obligation. And so once the court made the ruling, they were fine. Now they had sort of a dispensation, if you will, a civil dispensation from their faith because they had moral law saying you got to do this. As far as your question, I kind of get lost in it a little bit because I think that's the best, in some instances, that's the best situation for child protection courts. That's why that's why these thoughtful decisions are made, that not everything that happens within a family is criminal, but sometimes they need the attention of the court to order them to do these basic standards to protect the welfare and well-being of children. They're not necessarily criminal, but we've decided as a state that we're not going to allow our children to suffer needlessly. I'm afraid I might have lost your question there because I think there's so much policy and so many people have different ideas about, what one family's norms are versus another family's, and then how that ultimately develops our social norms. That's very difficult, but those are the decisions that I've been working on for my entire career. And I wrestle with them. I think I mostly make them right because those are the biggest decisions I'm going to make. But I don't know how else to answer that question because I think that's just a huge issue about policy in general.
Okay, Ms. Fisher, I'm going to ask a couple of quick questions, I hope, and then we'll take a 5-minute break, committee, before we get into the last part. I'm going to follow up with what Representative Kaufman asked you, and that is about difficult to prosecute under Title 18. The question is it impossible to prosecute as it's currently written?
I believe it would be.
And the reason why I ask that question is because it would seem to me that the way the statute is currently written, based on what you said, difficult, and then I have to then imply not impossible, that any question raised under that title then would have to be decided by jury. And isn't that what we have them for? It's up to them to decide whether or not there's been some kind of felony or criminal behavior under that. And this would go to a jury anyway.
Yes, Chairman, thank you. Do I think it's impossible? I don't think it's impossible, but as a prosecutor, I have a very, my ethical standard is much different than any other attorney, defense attorney, any other attorney. Prosecutors have a higher standard, ethical standard, and I can't even take a case if I don't believe that either the law is in my favor or I can be able to prove that case beyond a reasonable doubt. So if I were to take this case knowing that I have an exception that's right here that says I have a faith-based exception, and then you have the criminal law, and all things being equal, this family really is faith-based, they really do believe it, they really do practice it, that is their life, and regardless of the fact that they're watching their 8-year-old drowning for breath every day, and their prayers aren't working, but they're still working it, I don't think we could prosecute them, because you have a conflict of law. You have an exception built in.
Okay, last
Is
question.
it reasonable? I mean, the question is it reasonable? At some point, as a parent, as a society, we have to look at it and say, is this reasonable for this family, these parents, to decide that their faith for prayer supersedes this child's everyday suffering, having 13 seizures a day, and they're still praying every day to heal? Now, is it reasonable? If we didn't have the faith-based exception, a jury may very well look at that very differently, because some jurors may say, many jurors may say, that's just not reasonable. That life means more than that. And watching this child have 13 seizures a day, or watching a child who is gasping for every breath every day, and you're just praying about it, and nothing is happening, that's not reasonable. And many jurors might agree and say, yeah, this isn't right. And while you may not go to prison for this, we think that you should be held to a reasonable standard that this is neglect and abuse. But as it is now, you have a statute that says they have an exception, and the jurors are going to get it. And then they have to weigh the law.
Okay, one last question, then we'll break. You stated earlier that the Idaho statutes were modeled after the California statutes?
I believe that's correct.
Okay. If that's correct, then do you know if the California legislature created an unqualified defense to felony manslaughter, child endangerment charges, those kind of things, to parents who furnish prayer alone in the instance where they have a gravely ill child that lies dying for lack of medical attention?
Chairman Johnson, I don't know the answer, but I'm happy to research it and bring it back to you, and that wouldn't take long to find out.
I would very much appreciate that, and if you could get an answer back to Mr. Bush or Mr. Hoskins on this working group, I think that would be a very important point for us to consider.
Absolutely.
Thank you. Thank you, Ms. Fisher, for coming here today and for sharing your story. And
Thank you.
it is a tough issue, and we appreciate all your work and effort that you do on behalf of the citizens, the families, and the children. Thank you.
Thank you, I appreciate it.
Committee, why don't we take a 5-minute break, give us all a chance just to kind of stretch our legs, and then we'll get into the last portion of our agenda. Thank you, everyone, for being patient with us. I know it's kind of hard to sit and listen sometimes. You all want to jump up and say something, but we'll have our chance here in this next little section. Thank you. We'll reconvene at 11 o'clock. Okay, I'll call this meeting of the Children at Risk Faith Healing Working Group back in order. It's 5 after 11. And if you're following along at home, we're now to the 11 o'clock portion of our program, Input from Interested Citizens, and we have 3 special guests with us today that are going to address the working group. And I know they've been listening to us intently and have a lot of valuable information to share with us. And just as a reminder, a couple of things, as much as you can, let's focus on the statutes, the balancing of the state and the individuals, the things we've talked about, and not get sidetracked too much on some of the very tough emotional aspects of this issue. And also, when you come forward, if you would please state your name, who you represent, your purpose for being here today, and then when you address the committee, you don't have to be perfect about it, but normally you would address your comments through the chair and then to a committee member, a working group member. So we'll try to do that. Also, if you signed the sheet today, the attendance sheet, we appreciate knowing that you're here today. We will not be taking additional public comment today. That's just a standard form that's out for each committee. So in future gathering of this working group, we will provide for that opportunity, but it was not our intent, and it's not our intent now to provide any additional public comment. So the 3 folks that we've invited were involved early in the process, and we specifically identified them to present to us today, and so we look forward to their presentation. So first, I'd like to call to the podium Ms. Linda Martin. Welcome, Linda.
Mr. Chairman, committee members, thank you for inviting me here to speak today.
If you'd pull that microphone in front of you and state your name, who you represent, why you're here, and then enunciate, speak loudly so we can all hear and the folks at home. Thank you.
My name is Linda Martin, and I represent myself and the children in my family that have passed away from what I believe is medical neglect. My purpose of being here is I've been asking the state legislature for the last 3 years to make a change in the religious exemptions because I feel like the children need the added protection. For those who don't know my story, I was born in Boise, and I attended the Followers of Christ Church in Meridian until I left at 16 years old. I still have family members that are active in the church, and I had many children in my family that died from lack of basic medical care. Their only form of treatment was prayer and anointing with oil.
Linda, could you speak into the microphone? This is a tough room to hear, and then we lose it. Yeah, thank you.
There were no herbal supplements or alternative care, not even an aspirin for pain. The followers shun modern medicine, but the majority do go to eye doctors and dentists. My parents took us to a dentist regularly, and our eyes were checked yearly. We were allowed to have Novocaine, which is a form of medicine. We were allowed to have eye drops to dilate our eyes. That's also a form of medicine. I was told this was because they did not see dentists or eye doctors as saving a person's life. We also took our animals to be vaccinated. Our animals had regular veterinary care if they were sick or injured. I was told this was because animals have no soul and cannot go to heaven. There were a couple of deaths that had the most effect on my life, and these also raise a lot of questions about the law. The first one I will tell you about was my cousin Jerry. Little background on this, his parents were my role models when I was growing up. I did everything with them. They took me on vacations. I loved these people dearly. They loved children. They ultimately had 4 children. 3 were stillborn, 1 was born alive. Jerry was the one that was born alive. He died at 10 years old, or 11 years old, from untreated diabetes. My aunt talked to me while he was ill. He started losing weight. He was lethargic. He started sleeping all the time. A few weeks later, he went into a coma and died. I have a question about that because my uncle was not a member of the church. He was not baptized in the church, but yet he still got the religious exemption and was never charged with neglect, even though this was not his belief. So does a spouse of a parent who believes in faith healing, do they have more of a moral obligation to a child or to their spouse's religious beliefs? The other death that personally impacted me was my nephew, Stephen. He died from bronchial pneumonia just before his 3rd birthday. You have to excuse me on this one. Stephen was born with spina bifida and Arnold-Chiari malformation. Arnold-Chiari malformation is when the base of the brain is tethered into the spinal column by the spinal cord. It causes severe headaches and paralysis. My nephew was paralyzed from the waist down. He was not allowed to use a wheelchair. He was not given anything for pain. This child was forced to be on the floor and pull himself around by his fingertips. That was the only way that he could move. Just before his 3rd birthday, he died from untreated pneumonia. He drowned in his own fluids. The parents said they had no time to call for medical help, but yet they called my mother that lived a half an hour away. They called the other grandmother that lived 2 hours away. The elders of the church came in. They all prayed for this child while he was dying, but yet there was no time to call for medical help. Years later, Stephen's parents both decided to seek medical treatment when they were faced with their own illnesses. My brother ended up with a terminal heart disease that caused the pressure in his heart to build up until he ended up with a hole in his heart. The pain was so great, he went into the hospital. St. Al's flew a surgeon in from Seattle. They performed an experimental surgery on my brother that had only been performed 3 times in the United States. This prolonged my brother's life for 3 years. During that 3 years, he had massage therapy, he had physical therapy, he had pain medicines. He had everything that he denied his son. Stephen's mother had a stroke during the time that my brother was ill. She spent several weeks at the Elks Rehab Hospital getting the rehabilitation care that her son would have benefited from. She's still under medical care today. When I asked them why, they went to a doctor after they had denied all of their children medical care over the years. They said it was up to the individual choice. A 2-year-old or a 3-year-old child with disabilities does not have the capacity or the right to make that decision. These parents made the decision to let their child die, and it was a decision that they did not make for themselves. The only way I can see to prevent people from prevent parents from making a different decision for themselves than what they make for their child is to remove the religious shields in all 4 statutes. When children need stitches or bones set, the elders are called. Cuts are sewn up with a needle and thread. Bones are pulled back into place the best that the elders know how, and a crude cast is applied. This is all done without anesthetic. It's extremely painful. In the governor's task force and the fatality review board's report for 2016, they mentioned 10 deaths from 2011 to 2013. I have coroner's reports for 12 children that died between those same years. According to the governor's task force report, 10 of those children would still be alive had they received medical care. I've had a lot of concerns about the way the deaths of the children are investigated. In almost all of the coroner's reports that I've read, one thing stands out to me above everything else. almost the first sentence in every single report is, "I was called to the Followers of Christ house for a death of a child." Do you see in any other death report for any other children, "I was called to the house of a Catholic," or "I was called to the house of a Mormon member"? Why is this treated differently? I do have copies of the 12 Corners reports for the children. If you would like a copy for the committee, I can leave that with you. In Peaceful Valley alone, I made a list in July of 2014. There were approximately 600 burials. 210 of those were children under 18 years old. Out of those 210, 144 of those children died after Idaho implemented the religious shields in 1972. 62 of those children lived past birth. 82 were either stillborn or we don't know if they lived or not. Those are headstones that only have one date or no dates. There are children that are in unmarked graves that we have no idea who they are or even how they died. Because of the Idaho privacy laws, there's no way to have access to all of the records of the children in that cemetery, so you could actually get a clear idea of how they died or how many of them could have been saved. I also have death certificates for children going back to 1900. If you read the ones from 1900 up to present time, they're very similar. These children were denied medical care. Their cause of death ranged from pneumonia, cholera. One even said that the child ate too much fruit and there was no time to get medical help for her. I think out of the 30 that I have that are over 50 years old, there was maybe 5 accidents. The rest of them were all preventable illnesses. Most of the deaths, a large percentage, are caused from pneumonia and diabetes. These children would still be alive after one trip to a doctor to get a prescription for either insulin or an antibiotic. When I decided to ask the legislature to help these children and to make changes, I didn't take that lightly. This is my family. I care deeply about my family, but I care more about the children and how they're suffering. The way these kids die is inhumane. A child should not have to drown in their own fluids while people are praying over them. You know, a child is vulnerable. They have no choice. They depend on their parents to protect them. When two people create a life, they have an obligation to that life to protect it and to do the best of their ability to bring that child up to be an adult. That does not mean neglecting them. It does not mean letting them suffer needlessly.
Mrs. Martin, if you could maybe summarize in 1 to 2 minutes, because I would like to allow a few minutes for questions from the working group, please.
I have one more example on how these laws affect children and how it fails. July 2nd, 2010, there was an ATV accident near Marsing. A 17-year-old boy was critically injured. He was life-flighted to St. Alphonsus Hospital. Law enforcement was called in, and against the advice of doctors and against lawmakers' advice, the parents were allowed to remove this critically injured child from St. Alphonsus emergency room because of the religious exemption. I heard that this man lived. I do not know what long-term injuries he still has. And, you know, I have been to trials in Oregon of people that were convicted of manslaughter in the death of their children. No one wins. Parents lose a child. Other children in that family lose a parent growing up. And it's all unnecessary because I was taught like most people in the church were taught, that we were to obey the laws of the land. If these statutes are removed, most of these people will follow the law. You're not going to prevent every single one of them, but you will stop a lot of it. And you will help young people, young couples that have children that want to take their child to a doctor. They can say, it's the law, we have to. They don't have to worry about their parents shunning them. They don't have to worry about the church turning on them. And with that, I will go ahead and defer to the chairman and the committee for questions.
Well, first of all, thank you for sharing your personal story. That's very important to us and very valuable, and thank you. Committee. I don't see a question, but that doesn't mean we won't have one a little bit later. So, Senator Schmidt.
Thank you, Mr. Chairman, and Linda, thank you also for presenting. You described that if we were to remove these exemptions, families may make different choices for their children. Could it also be that families would continue making the same choices for their children?
It is possible that families would make the same decisions for their children, but I defer back to Oregon. Oregon repealed their religious statutes in 2011. Since 2009, there have only been 3 deaths in Oregon that are faith-related that have been reported. Those 3 were actually Church of the Firstborn members, which are closely related to the followers with the same beliefs. I attended the last trial in 2014. Most of the parents I have talked to, the young parents that are in the church, and the people that are in the church in Oregon City have indicated to me that they would like to have these laws changed because it takes the responsibility away from them. It's like when I brought this up and brought it to the attention of the public, I had family members that threatened to have me arrested if I ever contacted them again because my opinion is different than theirs. I have seen children that disagreed with the faith healing, and then they had a parent or a sibling die. They were not allowed to go to those funerals. They were not welcome in the family anymore. My brother had a disagreement with my nephew over the faith healing. My nephew was not allowed to go to his father's funeral, even though his father sought medical treatment before he died. We can't stop all bank robbers. We can't stop murders. We can pass laws that will prevent it. And that's all I'm asking you to do, is to remove these religious shields so there's no confusion. These laws confuse teachers. They confuse most mandated reporters because it gives them the impression that if a parent is a faith-healing parent, they cannot intervene on behalf of the child. When my nephew was ill, I actually called Health and Welfare, and I explained the situation and what religion my brother and his wife belonged to. They said, "We're sorry, they're not doing anything illegal. We cannot help that child." Do you know how hard that is on other family members to have to sit and watch a child suffer and have your hands tied and do nothing?
Thank you, Ms. Martin. Committee members? Okay, Linda, thank you. I think you drove quite a ways to get here.
I actually flew in tonight.
You
or
flew in,
last night.
yeah, so thank you for your commitment to being here today.
And Mr. Chairman, if any of the committee members want any of the news stories that will help clarify some of this information, I do have copies of all the coroner's reports. I have copies of news stories from Oregon at the time that they were changing their laws and what they were considering at the time too. If anybody finds any of that helpful, I would be happy to email a copy.
Thank you.
And thank you for having me here today.
Ms. Martin, you might leave a copy of that with our legislative staff over here, and then they'll make sure that the working group members get a copy of that.
Pretty fast,
Okay.
but I'll go ahead and leave copies of all of it.
Okay, thank you. Ms. Sarah Brady. Welcome to the working group, Ms. Brady. And in case you didn't hear earlier, if you would please state your name, who you represent, your purpose for being here, and then project your voice into that microphone, because we want to make sure that everyone hears in this room and at home today. It's very important that we hear from you, and the floor is yours.
Yes, Mr. Chairman. Senator Johnson and your name. Sorry. My name is Sarah Walton Brady. Senator Johnson and Representative Palmer and committee members, I appreciate the opportunity to speak with you today. A little bit about myself. I spent most of my childhood in southern Idaho, Declo, amidst wheat and potato fields, moving hand lines and driving truck for my grandpa. I'm from a rather large family. There's 10 of us in the bunch. I'm second oldest. I've been with my partner in crime for 18 years. We just recently celebrated our 16-year wedding anniversary. My husband has worked as a police officer for 14 years, and 8 of those years he's worked as a detective here for child abuse in the Valley. And I'm a stay-at-home mom to our 3 young children. Recently, a story, very personal to me, hit local, national, and international news. The story featured is of a young woman, my little sister Mariah, whose parents allegedly treated her congenital heart defect with prayer and faith alone. From what I've seen is those that are interested in changing the law have focused their attention on using my sister's story as an example to reform the faith healing laws here in Idaho. My intent today is to explain why Mariah's story, which has been highly sensationalized and largely false, should not be used as an example to change the faith healing law. The law states the practice of a parent or guardian who chooses for his child's treatment by prayer or spiritual means alone shall not for that reason alone be considered to have violated the duty of care to such child. IdahoChildren.org, a website advocating for the change in the faith healing law, explains the law this way, and I quote, "They insulate a parent from all of these laws privilege the most extreme behavior. They insulate a parent from criminal and civil liability if and only if the parent relies on spiritual means alone. If the parent uses any other means to try to heal or get relief for the child, he or she loses the exemption. If the parent combines prayer with orange juice or a cool bath to bring down a fever, if the parent gives herbs as well as ritual, if the parent relies exclusively on prayer for a week, then calls 911 in desperation, the parent loses the exemption." My mother did give a statement on Facebook rejecting the idea she used prayer and faith alone when she discovered Mariah's story was being used as a reason to change this law. She later on camera, along with myself on KTVB, confirmed that she had used natural medicine to address Mariah's symptoms. Even if my mother wanted to use the exemption, the fact is she would be unable to because she used other means to treat Mariah's symptoms, specifically natural, holistic, or alternative medicine. Our mother was knowledgeable in natural treatments. She worked at a health food store and later owned one and enjoyed helping people to overcome their health challenges. Here's a picture of Mariah and my mom at my mom's health food store. In regards to our parents being a member of a religion that teaches or promotes faith and prayer alone to treat sicknesses, it's been incorrectly reported in the news that they were members of the Church of Christ, the Followers of Christ, a Pentecostal sect, fundamentalist Mormons, or fringe Mormons. Here I have a copy of my parents' membership records. To set the record straight, our parents were not members of any other church except for the Church of Jesus Christ of Latter-day Saints, most commonly known as LDS or Mormons. And since I've been a member of the LDS faith my whole life, I feel it is safe to say that the idea of using prayer or faith alone to treat health concerns is neither a doctrine nor a tenet of the LDS Church, nor is the LDS faith a bona fide religious denomination that relies exclusively on this form of treatment in lieu of medical treatment. Our parents' choice to use natural medicine was not dictated by their religious beliefs, nor from a knowledge of a serious illness some say news articles may suggest. They were unaware of Mariah's congenital heart defect until the middle of August of 2013, 3 months after Mariah turned 18. If our parents had known about Mariah's heart defect, they would have not believed it would have healed, it would have not been healed by holistic medicine. I think that's a pretty obvious thing, that natural medicine wouldn't heal a hole in someone's heart. I would like to briefly address Mariah's health. The news has said Mariah Walton grew up struggling for every breath and has been battling to stay alive since birth. These are bold-faced lies. I never saw Mariah ever struggling for every breath or battling to stay alive while she was a teenager or child. She did have mild health symptoms. We blindly attributed to allergies or possibly mild asthma. I remember taking Mariah sledding with our siblings and swimming at Zim's Hot Springs, a favorite family activity. She enjoyed reading and playing with her friends, jumping on the trampoline. Never at any point did I feel that Mariah needed immediate medical care or that her life was in danger due to her symptoms. If I had seen Mariah needing immediate care, I would have taken the necessary steps to get help for her. Mariah has 8 older siblings, some who held jobs that required mandatory reporting, such as 3 daycare workers, a trained EMT, and a brother-in-law who was a police officer. Family members who are dedicated to the health and well-being of society, and especially their own family. No one was turning a blind eye to a sick child, as the media implies. After Mariah turned 18, her health declined in spite of receiving consistent medical care. In the summer of 2014, Mariah was on life support after health complications unrelated to her heart defect. Mariah's current health is significantly worse than at 18 when she was diagnosed. I do have an album of pictures of Mariah and several statements from close family friends supporting what I have said today regarding her health. You're welcome to look at those. It's been very devastating to our family to see Mariah go through this. The last thing we want to see is our little sister hurting and suffering. If any one of us could go back with the information that we have today, we would all have made different choices. I do believe my parents had the fundamental right and responsibility to determine how Mariah was raised and cared for. I do not believe they were negligent, and if any time I thought my little sister was being neglected, medically or not, I would have intervened with the legal or current legal processes in place. Regardless of what anyone's opinion is about the course my parents took to address Mariah's health, the fact of the matter remains Mariah is not a victim of faith healing. I am concerned about my physically and developmentally disabled sister being used for a political agenda. I've noticed organizations whose intent to change the law and using Mariah's story under a false narrative that she's a victim of faith healing. I reached out to some of them to educate them to stop using Mariah's story because it wasn't applicable. One of those organizations was Protect Idaho Kids, running the Let Them Live campaign. Mariah was on a commercial. She's being used as a poster person to change the law. They were fundraising for Mariah on a GoFundMe page and collecting signatures as well, using Mariah's story as a reason to change the law. When I reached out to Mr. Wingate, I've got a long email here, so I won't read all of it, just some excerpts. I was essentially told, let this go. This is not about Mariah. If, because of faith healing or not, Mariah will remain a portion of our drive to repeal these laws. Her condition is inexcusable. Regardless of the pleas you present, her story may save other children's lives, and that is the important point. No, I disagree. I don't care if it's to save 1 million lives. I don't think we should use a lie and try to change something based upon a false narrative. Another organization, Children's Right to Live Idaho, who made a public post on Facebook referencing Mariah's story and referencing my mother's rebuttal on KTVB, implying my mother was lying about using interventions. I rebutted the assertion publicly. My comments were deleted. My emails were ignored. I was hung up on and told that they were not interested in discussing it further before I could respond. Child Friendly Faith also has been urging legislators to be contacted using Mariah's story as a reason to change the law. I don't have time to go into every interaction that I've had since Mariah's story has aired. But I believe after hearing the facts presented to you today surrounding Mariah's childhood and the fact that she is not a victim of faith healing, I respectfully ask anyone who is listening today to stop using her as an example, to change the law, and to refrain from using the term Mariah's Law. Thank you for your time today. Representative Paulman and Senator Johnson and committee members, I stand for questions now, and if it's okay, my sister's here to answer questions as well. This is Rachel Walton Ward. Hello.
Well, thank you, Ms. Brady, and welcome, Rachel. Thank you for sharing your story. That's not easy, I know, but we do appreciate that. Committee members, questions? Senator Schmidt.
Me again. Thank you also for presenting your story, I'm sorry for the situation you find yourself in. I understand that and believe me, I've done this for 6 years, so I've seen things in proposing or pushing for legislation that are similar to what you're describing, and I'm sorry.
Thank you.
You also described that this story's being used to misrepresent or to ask that this law be changed and you're saying it's a false purpose. I would like you to try to step back from that, because that you've been hurt by that, and I understand that. I would be too. But the greater purpose for me is to serve the children of our state. And I believe as policymakers, we have an obligation to do that. Can you think of a way we could help serve the children?
Ms. Brady.
Chairman and Senator Schmidt, are you asking if I can think of a way to use Mariah's story to help? Is that the question? And
Well, Mr. Chairman, just as a source for clarification, I apologize. We write laws. We change laws. And we've been struggling today with what is the purpose of these laws. The purpose of these laws is to try to serve children and also protect freedoms and respect the family. We have to balance that. And I understand that your situation, maybe people have gotten out of balance in terms of how they're portraying things, but we, as lawmakers, need to understand this balance and strive for it. And I'm asking for your wisdom, for your support in our effort. So, I don't believe personally that prosecuting parents makes them be better parents. But I do believe stating goals can. Would there be a goal for children's health that we could help state, that would have helped your sister, helped children that are suffering?
Ms. Brady.
Chairman and Senator Schmidt. My concern is that at what point do we stop with a law for everything? I mean, Mariah's situation, we could have forced my parents to take her to the doctor when she was born. We could stop people from having home births. I personally have a problem with that because I had a home birth. We could force people to do well baby checks. I personally have a problem with that because I don't want to be mandated to take my baby in every 6 months or whatever it is. And then who pays for that if you're mandating that, right? Do I pay for that or do you pay for that because you say I have to do it? So I do believe there's a fine line, but I also am concerned about religious freedom, right? Because that's a concern. But then the health of children is a concern. And so I don't know if I know enough about the situation with the, with what Linda was speaking to. I feel like I would need to know more details on that to speak to how I could help you, and I need to get more involved. Does that answer your question?
It's your best effort. Thank you, ma'am.
Thank you.
Thank you, Ms. Brady. Okay, I see no further questions. Thank you and Rachel for coming today and sharing your family with us in the story. It's very important for us to hear these stories, and as Senator Schmidt mentioned, our job is to look at this and have good policy, hopefully. So it's a very important part of the process to hear from you. So again, thank you for coming today.
Thank you, Chairman, committee members.
Rachel, if you wanted to leave that, I don't know if you're on a tight schedule, but if you want to leave that somewhere where if working group members want to page through that, you're sure welcome to do that. Thank you for bringing that. Mr. Seavey, our last speaker today is Mr. Dan Seavey. If you would please, if you're willing, come to the podium and state your name, who you represent, your purpose for being here today, and to speak clearly into that microphone. Pull the microphone down so we can hear what you have to say. It's important to us and for the folks at home listening. So welcome and thank you for being here.
Chairman, committee members, let me begin by thanking you for allowing me to be here. I say allowing, but I'm really quite reluctant. But I recognize the need. That being said, this is the first time I've been in front of a committee like this. So, and I'm a child of the sagebrush, and I might be a little rough, so let me apologize in advance for that. I represent, I don't really represent the church. I represent people interested in freedom and freedom of religion. I guess I might be able to say I represent a faith-healing people. You know, it's quite the question, and I've been doing a lot of study on it as of late. I've been working on this issue for a number of years. Over time, I've been turned from somebody who just wants to mind my own business and dig in the dirt to what I flippantly called a faith-healing Christian apologist. And I don't like one little bit of that. There again, I see the necessity. You know, there's a number of issues here that you're all aware. I want to point out that we believe in freedom of health care. Not free health care, but freedom of choice of health care. I take a little issue at calling it a religious exemption in which the state in a statute recognized another treatment form being treatment by prayer alone. Each man, each one of us has our own conscience and our own feeling about how to take care of ourselves and our health care. And each patriarch or matriarch or co's, however it might properly be said, set of parents, has their own personal property right. One of the most basic property rights in this world is to your own body and to your faith, or lack of, however that might be, and to your children. There is no greater intrusion than into your own personal space of your body and your family and your faith. The state, I realize, does not take that lightly and never has. As far as faith healing, it is constitutional. We all agree on that. And but laws are tools. And you know, I'm a man of tools. I use a lot of tools. But we don't always use a tool correctly. There's an old joke Never use a 10-inch crescent as a hammer if you can use a 12. But laws are tools, and sometimes we misuse our tools. And people will misuse laws, and people will misuse people. Unfortunately, abuse is real. Neglect is real. Tragically, statistics have shown around 1,500 children per year in the United States die of neglect and abuse. Some put the numbers of attempted faith healing in that. I'm sure they're included in that 1,500 number. But also, really quite tragically, the medical profession is responsible for as many as 440,000 deaths per year in the U.S. through medical error alone. I couldn't personally, in all my research, find numbers for how many children was included in that 440,000. However, using the governor's report for children at risk for a child mortality rate against those numbers, I did run the math, and I came up with somewhere around 15,000 children killed by medical error per year. That's a busload of kids per day, nearly. I don't think any of us would put up with that if it was in front of our eyes. The medical profession, I understand, they want to help. Their intentions are good. But our intentions are good. Life extends beyond this earth. Suffering is real. It's real all over the world, and it's real right here, and it's real personal. And there is no greater suffering than one that is personal to oneself, whether it be himself or his children. And I, as a parent, find the suffering of my children far greater than my own. I think each of you could agree with that. None of us wants to see anybody suffer. If you do, there's something wrong with you. As far as the point of law, the statute, as I said, recognizes faith healing in the state of Idaho. Some want to call that backwards. I call it progressive because there's many forms of treatment, not just state licensed medical practice. Some people want to go for a more holistic treatment. Some want to do a vitamin therapy, as was mentioned. I'm not even going to go through them all. As a matter of fact, they were addressed by a New York Court of Appeals justice that you might be familiar with. I could get the paperwork out and quote his name, but I won't bother. Back around the turn of this century in 1900, in which he recognized very many of those forms of treatment. In that case, there was a child had died, and they were convicted for the death of that child. They used prayer alone, and they were convicted for the death of that child. However, the court said, in the judgment, that the state of Massachusetts, they simply upheld their statute. The state of Massachusetts did not recognize anything, or excuse me, I'm telling you wrong, the state of New York did not recognize any form of treatment other than licensed medical practice, licensed by the state of New York. This has come up many times as a point of law, but really as a point of faith healing, not that often. Folks of my persuasion, of our persuasion, excuse me, have tended towards the frontiers, and when civilization encroached too much, we moved again. But you know we're out of frontiers. And now I guess we're going to have to stand up, and as our families have done all through the history of this nation, we're going to have to fight for freedom again, as they wish to take away our freedom of choice, of personal choice for our own health care. I stand with anybody that believes in that. And I don't care if it's faith healing or what, but we each should have our own personal choice for ourselves and our family. That's where I go with it. We practice what you call faith healing. A lot of people think of some spectacular spectacle that you see on some of these TV preacher evangelism shows. No, that's not what it's about. This is a way of life. We live it day to day, every day. If we are injured, sometimes we just pick up and go on. Sometimes we feel it's more serious, and we refer to the Lord to take care of us. In that instance, we also, in recognizing His supreme judgment, recognize that sometimes it isn't the result that we would really care for. Again, I have to say, life extends beyond this earth. And when it's all over, we believe that all of this will have been a blink of an eye, and well, what was all that fuss? As far as adherence to any law, who do you better obey, God or man? I claim to be a citizen of the state of Idaho, which is a member state of the United States of America. I'm not subject to any king except my Lord and Savior. And in that, I claim dual citizenship. I'm a member of the kingdom of God. And as Paul did, he proclaimed his rights as a Roman when it worked well for him. And I proclaim my rights as a citizen of the state of Idaho and the United States. We do have a constitutional freedom of religion. If in practice someone disagrees with that, well, you know, it's very normal to disagree with your neighbor or your friend or your wife, for that matter. And it always seems that when somebody makes choices you disagree with, especially if you consider yourself more educated than them, well, you just think they're stupid. They're uneducated. They're just people that dig in the dirt. They don't know anything. They're ignorant. But that man might have a wisdom that you aren't unable to equate with. And he might have a different goal in mind. Our goal is eternity. It isn't here. Our goal is not suffering. However, if this country should take the same way as Rome did with the Christians when the Christian religion started, then we will be boiled in oil and crucified and skinned alive, as the saints were before. Faith healing was recognized by that justice in that New York case, and he did speak of it all, and he spoke of the known efficacy of it through some of the English royals in the history. I can show you I can give you that court case if you want to read it. If the statute is changed, I'll not change anything I do. Because as Daniel did, he went and he prayed. All Daniel had to do was take a month off, or maybe not open his window, but he wouldn't bend one bit. He worshiped his God as he did before, and so will I, or so I hope. And so will us all. I've been instructed not to use the words me and I. And when I do say those, I do mean we. I have a lot of people back here that have come with me. A very small number of our people. Would it be untoward, Chairman, if they were to stand for a moment to be recognized in support of this?
Chairman, I will allow it. Thank you,
Thank
Mr.
you.
Seavey.
I figure short's better. I'm short anyway. So I'm ready for questions, sir.
Thank you, Mr. Seavey. That was very well done. Committee. Senator Sidaway.
Thank you, and truly thank you for that testimony. And you know, I assume we have a lot of similar beliefs from just listening to what you said. And I'll say this: people that know me well may contradict what I'm about to say, but I consider myself a man of faith, and but when I say that, I guess when I look around me and I count my blessings every day, I include in that count the things that I feel God or my Lord and Savior has given to me. And He has given to me, or given to our society, He has given to all of us certainly the most important thing is our ability to make choices. But along with that, He has given us knowledge. And we learn line upon line and precept upon precept. And as we advance and have advanced throughout history, we're now into a situation where medically we can fix and address a lot of things. And I feel like, you know, those are gifts from God, and we should use those gifts. So while I may bless my children, my family, my friends, and pray for my children, my family, and my friends when they're in need, I also, when I send them, when I make that choice to send them to that doctor or medical provider, that I pray for that provider also, that they'll be there. But I don't know if I'm hearing that from you. And I just wondered if you could maybe expound a little bit, and if you believe that the gifts that we have available to us, that have been given to us by our Creator in the field of medicine, that are here, if you, I guess, believe that those are gifts from God, and if they are, do you believe we should use those gifts? Does that ring? Does that make sense? Does my question make sense to you?
Mr. Chairman, Senator Sidaway, I think I get where you're going with that. If I may attempt an answer. I'll start with God gives His gifts as He will, to whom He will, to what degree He might. I'm sure might be someone in this room that doesn't even have any faith in the power of prayer as opposed to myself, that I have all faith in the power of prayer and the results it gives. I have complete confidence in your freedom to make your choice for medicine, and I would have every hope that it is effective for you. However, we believe that pharmaceuticals and medicine is a product from Satan. The root can be found in one of the lost books of Enoch. Pharmaceuticals is a word derived from a Greek pharmakia. The words in the Bible, witchcraft and sorcery, have been in English, they go from pharmakia to witchcraft or sorcery. We are strictly forbidden from those things. And it says further in Galatians that those who imbibe in those things will not attain a home in heaven. That is our belief. We use it to condemn no one but ourselves. So we, like I said, we respect your choice and your belief and hope the very best for you. And I've often sat at the bedside in a hospital of someone I know in support of them, as a matter of fact. Wasn't my choice, but circumstances went so that my grandchild happened to be born in a hospital in Caldwell. I was there. You don't think a grandparent was going to be anywhere else, do you? They knew that I didn't support that, but they felt it was necessary for them, and they're of age. They do what they will. And I see my grandbaby just as often as I can, and my son and my daughter-in-law. It just happens that my daughter-in-law was Catholic. We're doing our best to corrupt her into our way of thinking, mind you. And I love her greatly, and she's a fine lady. And I love my grandbaby, and I love my son. Sometimes I don't love his choices. But we find a lot of times, and in my clan, it just happens that maturity comes a little later in life than we'd like, as it did with myself. And there I'm using me again. So, that being said, we disagree with medicine, and we do feel it does put our very eternal life in jeopardy. And pray that it doesn't you. But our conscience condemns us. But as Paul said, if you're condemned, don't eat of the fruit of the food. I'm probably misquoting it. If you're not condemned, eat of it. So, blessings to you if you feel it works.
Thank you.
Senator Schmidt.
Thank you, Mr. Chairman. Mr. Seavey, I greatly appreciate you sharing your views with us today, because it is important that we understand how you make the choices you make and your beliefs, and you were very generous to share that with us. You talked about choices in the last response you gave, and I kind of want to focus on that, because you described, and I appreciated that you said it's important that you use the plural pronoun we instead of I. So let's talk about how those choices are made. And what I've been focusing on in this examination is the well-being of children, who, whether we're right or wrong in the law, we kind of say they don't have the same rights as adults do. And so I guess the first part of my question would be how your group, your faith, makes decisions for children.
Mr. Chairman, Senator Schmidt, I'm glad you asked that question. And I've heard about children's rights, but of a practical sense, as much as nobody wants to hear it, children have no rights. Children are not endowed in anybody's estimation with the mental maturity to make choices for themselves. And so they are always subservient to their parents, guardians, caregivers, or the state. The state, over many years, has made it patently clear that they consider parents' choices and the children's choices subservient to theirs. So I take some issue with talking about children's rights. As children have no rights, the states have made it clear they belong to them or the parents. That being said, we make choices in our children's best interest. And our best interest has a lot to do with eternity and service to our Lord and Savior. We prefer, naturally, that they would be here with us and comfortable. As I said, nobody wants to see anybody suffer, especially their children. And we preach and try to practice pacifism. But when your children are suffering, all bets come off, even with us, because we don't want them to suffer. And because of that, sometimes some people do defer to medicine. I've heard it said they get shunned. Well, I have known some people that have done that. But most of the people here today will not do that. We make choices for our children, best interest for them, in their best interest, including choices of eternity. Now, we do no harm to our children. That's one of the great things about prayer. It inflicts no physical harm. It inflicts no mental harm, I contend. We contend, excuse me. However, medicine, licensed practice medicine, often does, as I've illustrated, in the death toll. And that's not even talking about the number that come away harmed in some way that survive it. And I've got other studies here that show that pharmaceuticals with children is a lot tougher deal than it is with adults. For one thing, you don't know how they're going to react, how their bodies are going to react. It's hard to adjust the dosage for a child. And they have a lot worse time making good choices medically for a child. The statistical harm for a child is likely much higher than it is for an adult. So medically, you should be far more cautious for your children than you are for yourself. I would advise that myself. I'll use that word this time. Thank you.
Okay, I'm going to ask a quick question, Mr. Seavey. Just if you can briefly describe for me, you mentioned earlier that you have dual citizenship. And one of those citizenships involves the state of Idaho, its laws, its statutes. And the state of Idaho has a policy, it's in 16-1601, that declares to be the establishment of legal framework conducive to the judicial processing, including periodic review of child abuse, abandonment, and neglect cases, and the protection of any child whose life, health, or welfare is endangered. At all times, the health and safety of the child shall be the primary concern. So that kind of sets up, I think, the state's interest in this matter. And we have to balance that against your interest as a parent with custody over your children. I know you don't like the term religious exemption, so I'm trying not to use that. But we have to balance the state's interest against your interest as a parent. And the state has established that interest, and you have established your interest. So somehow we need to work together on this. And earlier you said that if the statutes are changed, it won't change what you do, your beliefs and your faith. And that may or may not result in a situation where neither one of the interests are met. But it's going to happen. And it's already in statute today. And so we heard, for example, about Title 16, where if there's a concern with the health of a child, where the courts can get involved. So it's already been established that the state can express that interest. And certainly on the criminal side, we're going to explore that more later as a working group. But how do you, or how will you, I guess, balance your interest against the state's interest? Because I don't think the state's going to give up on their interest, as stated in 1601. And this committee will look at that and we'll talk about, this statute and other statutes. That's part of our charge. But as we look at trying to balance the state's interest against your interest, for example, the custody, control, care of your children, we have to try to find something that works for both of us. And so I think the question is, if we find that balance, is that something then that you can work with, that you'll accept, and the state will do its part? And if the answer is don't change the current statute, then I don't know where we end up on that, because we still need to look at that. But if there's something in the statutes we can look at that as best we can tries to balance those interests, I think that's what we're trying to reach as a working group. And your testimony was, in my opinion, very profound. And I would hope that we could find that balance and work together on that.
Mr. Chairman, ironically, coincidentally, our interests are the same. We both want to protect the children, so we have no conflict on that point. It appears the conflict becomes on the definition of neglect. We agree that the state and we agree that there is indeed abuse and neglect, and it does happen tragically. We don't put up with abuse or neglect either. We take measures, whether legally or within ourselves, to take care of those things. And it has been so done in the past. I can't cite any particular instance because I just can't really bring it to mind, but we take care of it, or we ask the law to step in. That being said, the issue seems to be the definition of neglect. I perceive that people wish to redefine neglect, that word, which used to have a real meaning. The best thing I could come up with is, and this might sound a little radical, is realize there truly is sometimes neglect. But it appears to me that only state licensed medical care will not, if you was to institute state licensed medical care as the only form of treatment, all else is by definition neglect, and that is unacceptable. I don't see how anybody, if they really reason it out, how any of you could really get along with that idea. I think you would agree that that's unreasonable. So my radical solution is to recognize more than faith healing as treatment. Because treatment is treatment, although you might not agree with my treatment. And as I said to the other Senator Sidaway, I may not agree with his treatment. But I do agree with our freedom to make those choices for our treatment, and each patriarch or parents to make their choices for their children as in their best interest. Now, that being said, the state will still have to have an enforcement arm, and I have personally experienced that, and it is, in my opinion, quite effective.
Thank you, Mr. Seavey. Senator Hagedorn for the last question.
Thank you, Mr. Chairman. Congratulations on your granddaughter, by the way.
Thank you very much.
And that's kind of the subject of my question. As you were describing sitting in a hospital when your granddaughter was born, you had mentioned that it wasn't your choice, but your daughter-in-law was of age and could make that choice on her own. And so my question to you is, you and your faith, what is the age of for a child to be able to make their own decisions?
May I ask you a question? Oh, excuse me, Senator.
Mr. Seavey.
Chair and Senator, may I ask you a question?
Senator Hagedorn.
Do you have children?
Mr. Chairman, I do.
Thank you, Chairman, Senator. If indeed you have children, and I believe you do because you said you do, you know the answer is each child determines that for himself in the eyes of the person who decides when it's time to give them the choice and how much choice. That raises an issue I've heard mentioned in this meeting in that they talked about older teenage children starting to make their choices for themselves and wanting to refuse medical care. If the state will make their choices for them, when will the state deem that they're mature enough to do so? Is it just going to be a number like 18, 21? We've all asked the questions. You guys are not that much different generation than I am. How is it you're old enough to carry a gun but not drink a beer? And, you know, these are paradoxical things that really have no straight answers. So forgive me for not giving you a straight answer, but that's the best I can do.
Mr. Chairman, thank you. That was the exact answer I expected, and I appreciate your candor. Thank you.
Thank you, Mr. Seavey, for being here today and for everyone for attending. And I'd especially like to thank the youth that you brought. And Rye, I remember your name, and I'm sorry I don't remember the two girls. But thank you for being here today. It's very important that you watch your government in action and that you take an interest in that. So we're depending on you. You're our future. So thank you, Mr. Seavey.
Thank you very much, Chair, Senators, Representatives. Excuse me for not saying that. I said I was brought up in the brush.
You did very well. Thank you. Committee members, we don't have anything left on our agenda. And I guess with the co-chair's concurrence, I would suggest that the co-chair and I visit about a follow-up meeting and then get that information out to you if that seems reasonable. I know that it's a busy time for everyone, but he's nodding his head. So the co-chair and I will get together and visit with our staff, Mr. Bush and Mr. Hoskins and Ms. Laura, and we'll put something together, get that out to the committee. We'll make sure that the public gets adequate notice on that. And if you came today with the expectation or hope of speaking to the working group, we will provide an opportunity at some future date to do that because it's very important that we hear from you also. So thank you for coming. We stand adjourned.
Welcome to Idaho in Session. Idaho in Session is sponsored by Don't Fail Idaho, the Idaho State Broadcasters Association, Union Pacific, with additional support from the Idaho Association of Counties, the Association of Idaho Cities, the Idaho Cable Telecommunications Association, and the Idaho Public Television Endowment.